Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. We invite you to talk to us one-on-one to establish an attorney-client relationship if that's what works best for you, or just subscribe and learn and listen to the podcast. We are on week 5. This is episode 20. We're talking about design patents this week, and we're going to talk about defending against a design patent cease and desist letter, or the design patent dilemma, strategies for responding to a cease and desist letters. According to the United States Patent and Trademark Office, over 50,000 design patent applications were filed in 2022 alone, which is more than a 15% increase from the previous year. As I've already discussed on the previous episodes this week, with the major jury win by Apple that partly was from a design patent on the iPhone against Samsung, $1 billion verdict. And of course, they didn't end up paying $1 billion. They appealed it. They went on. But that $1 billion verdicts still happened, and it still made a major impact in the industry. And so over the past 10 years, design patents filings have gone up and up. And so you might receive a cease and desist letter for an alleged design patent infringement. If you do, it's important to respond appropriately to protect your business and avoid potential legal consequences. Failing to respond or taking the wrong action could result in costly litigation and damages to your reputation. There are cases where even major companies have challenges because of patent lawsuits that pushes them into hard times, into bankruptcy, reorganization, things they don't really want to go through. So understanding these issues, and I'm not talking to those companies. They've got their attorneys. I'm talking to the small law firms. I'm not the small law firms. I am the small law firm. I'm talking to the small businesses that they don't have an attorney on staff. But I can be a resource for you through this podcast, or if you want to talk to me directly, you can schedule an appointment. And so by understanding the strategies for responding, you can protect your business interests and avoid infringement claims and potentially even a lawsuit. So if you receive a cease and desist letter allowing or alleging design patent infringement, there are a few things you need to know. You need to understand the allegations. Carefully review the letter to understand the specific claims of infringement and the rights being asserted. If the letter is vague, if it doesn't say what patent you're infringing or what product that you're selling that might be infringing, then that letter may be in violation of anti-patent troll laws. There are over 30 states in the United States that have passed anti-patent troll laws, and what they generally cover, they're not all the exact same, but they are all pretty similar. That's why they're all categorized together. But generally it covers bringing a lawsuit or even sending a cease and desist letter or making an allegation of infringement if it's overly broad, if they don't really have details saying why you're infringing, or if they don't have a valid basis, if they haven't done any analysis and they say, well, we're just going to generally point at you and say, you're infringing one of our patents and we have 1,000 patents, so pick one. That's what a patent troll might do. Specifically, more often, what the patent trolls have done, and these laws started in around 2013 because small businesses like you were getting hit by these companies. They would buy up old patents. They're not expired, but they're old, and they're applying them to new technology that it's questionable whether or not they actually apply. And they would ask for small settlements, $1,000 to $5,000. A patent lawsuit's going to cost you a whole lot more than that. So their strategy was allege, broadly, the scary patent lawsuit. They actually have the ownership of a patent, and then get a small enough settlement that you don't want to go through hiring an attorney, going through a lawsuit. So it's easier to just pay them off and say, go away. And so laws have been introduced, and there's a case pending in the state of Washington where the Attorney General has used one of these laws to go after a company that has been enforcing patents in this way. And that case is still pending. We don't know where exactly it'll go. It started in 2001. It's 2023 now, but that's the way lawsuits go, even when they're brought by the Attorney General. So one other thing to know is you're going to need to do research if you receive a cease and desist letter to understand the scope of the design patent. As I talked about in one of the previous episodes this week, a design patent is narrow first of all, it's narrow in that it needs to be the same product. A design patent is for a specific product. And if you're not selling that same product that the design patent shows, then it's not likely that you're infringing. But also one of the cases that I've reviewed in the past was a coffee maker. And this is just from case studies. So a coffee maker, there's hundreds of coffee makers out there that all look pretty similar. And so some of the design elements, you could change some of the way it's shaped, make it more round here, more square there, and you can have a unique design. But the general design of the where you put the water in, where you put the coffee pot, where some of the buttons are, those things are those are so common. If you're in the same or similar ways, those aren't going to distinguish the design patent. So the research, what it needs to do is find out, as of the filing date of that design patent, what was the closest available design that was publicly available, whether or not it was patented. If it was on the internet, even if it was a concept design that somebody had published, they weren't actually producing it, it's still considered a design that is publicly available. You're going to need to research that so you can understand if the scope of the design patent is narrow or broad. That's one of the, it's both a challenge and an opportunity, that the design patent isn't as clear as a utility patent. With a utility patent, you can read the claims and say, am I doing everything that this claim says? If you're not doing everything that it says, then you're not infringing. Or you can look at it and say, okay, maybe you could say I'm doing them all of them, but I'm going to go ahead and redesign my product, so I'm taking out one of these steps or one of these elements. You can do the same thing with a design patent to avoid future infringement, but you're going to need to do some research to understand how broad that design patent actually is, so that you know if your redesign is going to still cover that. With Samsung, Apple was the innovator that came out with the phone without a physical keyboard. And so trying to figure out how to design around that was probably pretty tricky for them because it was such a big departure of what had been done before. You're going to want to work with a patent attorney to, or an intellectual property attorney. It doesn't necessarily have to be a patent attorney that can file patents if you've received a cease and desist letter, because it could be a litigator that they litigate patents and they know how to defend. And but you're going to want an experienced attorney who's experienced with design patent infringement to evaluate your options for responding and determining the best course of action. You typically do want to respond promptly to a cease and desist letter. The saying is that a bad settlement is often better than a good court case, because oftentimes that settlement actually ends the pain, the heartache, the headache, and just gets on with life. Whereas the lawsuit, you're kind of on hold for a long time. So you're going to want to, it's likely that there's a way to end this if you address it either through negotiation, a license agreement, designing around for future stuff to limit any future damages, and then if you need to, take a license. So let me know what you think of my podcast and subscribe so you don't miss out on valuable information for your business. Next week, we're going to talk about copyright essentials, the protection, ownership, infringement, and response strategies. We're going to talk about copyright protections, how long is it, what is covered, and strategies for registration, qualifications for copyright ownership. We're going to talk about ChatGPT and OpenAI. We're going to talk about what can you copy on the internet? Words, images, videos, music, etc. So don't copy any content until you listen to next week. And what do you do if you get a copyright infringement cease and desist letter? So that'll be next week. Thanks for being with me this week. This is Wayne Carroll with Leveraging Inspiration.
Convert them into smart devices, essentially retrofitting any circuit breaker panel